Hey guys. So I honestly don't even know where to begin with this lesson because my brain is so close to burnout at this point. I mean, honestly, most people in my position would have made it this far, and I don't blame them. Now I have to apologize. This lesson is going to be long because this story is long, but it is also going to be filled with a lot of knowledge and information. So I'm going to try to put everything in the notes for you below so you can choose what you want to listen to, what you don't. I'm also have created a resource for you guys that I'm also going to be including in the notes. So if you are in my position, you have a guide that will help you get through this. Now, before we dive in, I have to make a disclaimer. I'm not a lawyer. I'm not allowed to give you legal advice, no matter how much I understand the law. My goal is to help you understand your options, what the law says, and what happened in my own case. And it's up to you to determine if your situation applies. And if you're unsure, you should seek advice from a lawyer. And to make it clear, when someone says, like, I can't give legal advice, it doesn't mean that someone can't state the law or specific policy. So when I mention something, then I say, according to law, that's simply stating the law as written. There's no interpretation needed. Some laws are very straightforward. However, there are a lot of laws that are intentionally broad or vague, which allows courts to interpret them over time, shaping new case law and setting legal precedents. As a self-represented litigant, I'm allowed to interpret these vague laws as they relate to my situation only. I estimated that I've spent over 300 hours on this case in the last 8 months, and I can't even guess how many more are ahead of me. But my circumstances are also very unusual. My case is against my previous landlord, DeSantis Rentals, LLC, in North Carolina, that I initiated after I felt that the owner, Anna, violated my tenant and civil rights. As I mentioned, I'm representing myself because I have been forced to. And this is also known as a pro se litigant in the legal system. This is a civil matter, not a criminal one. There are different types of laws and different types of courts, and each has their own set of rules. If you're defending yourself against a crime that could lead to an arrest or criminal charges, that falls under criminal law, and this lesson won't apply. But if your case involves consumer rights, landlord-tenant disputes, contracts, constitutional law, 14th Amendment, then keep listening. Now, when I say that I'm suing my landlord, this is not about me fighting an eviction. There's a clear distinction between these two types of cases, especially in North Carolina, and there's different processes behind them. So if you are getting evicted, some of this will apply. There's some information at the end of this lesson you might want to know, but understand how it will be managed in the court system is a different process for each. Additionally, even though my case is specific to North Carolina and every state has its own set of rules that you will need to learn, some aspects of this does involve federal law. Now, this lesson is going to share a very condensed version of my experience. If I shared every detail, this would have to be a series, and I just don't have the energy for it. But if you're interested, you can view all the public court records online if you want a complete picture of this case. Because Anna's presented her own version of events, which differs from mine greatly. However, because defamation is involved in this, I want to clearly distinguish between facts and my opinions. For example, what I can state as a fact is that the property that she rented to me was misrepresented. While the courts haven't issued a final ruling yet, the city of Raleigh conducted its own inspection and identified 14 code violations, officially deeming the property unfit. For other violations, I believe I have enough evidence to prove them as fact, or I wouldn't have a case. But there hasn't been a final ruling, so for now, they are just considered alleged, and she's, of course, innocent until proven otherwise. My situation, though, has become so unusual and so complex that I have felt compelled to share this story now before it's even fully resolved. This is because I genuinely worry about my safety. This legal battle is currently involving disputes against the Department of Justice, the North Carolina Human Relations Commissions, multiple district judges, the Office of Administration Hearing, and now, as of today, the Court of Appeals. This alone is intimidating. Navigating a system where there's powerful judicial figures and state-appointed entities are involved is daunting, especially someone new to this area without any established connection, on top of dealing with Anna and two different attorneys that have acted, in my opinion, in extremely bad faith. Now, throughout this process, I've been accosted in court, accused of being the problem, and suggestions of courts that I don't know what I'm doing. All the while, the opposing party has openly violated court procedures without accountability. I have diligently followed every rule, yet I've experienced what feels like judicial bias or misconduct. which really raises an important question of why or how is this even happening? Because the legal process is intended to be straightforward, governed by rules and rights to ensure due process. It's a constitutional guarantee. But one that breaks down, bias or even corruption is often involved. Now, while I'm not suggesting by any means a grand conspiracy, it would be naive to ignore how power and influence and systemic flaws can impact fairness, especially in civil disputes. And I've tried to logically reason through all these possibilities. Like, is it because North Carolina's well-known bias against tenants? I mean, possibly. Even after contacting numerous law firms and consulting attorneys, I've discovered tenant cases in North Carolina are kind of seen as unwinnable or prohibitively expensive. Or is it because I'm representing myself? Pro se litigants frequently face prejudice and disrespect, even though the courts are supposed to accommodate them. But despite meticulously following procedures, I've been treated as an issue rather than a participant exercising my rights. Or perhaps it's because Anna's false narrative is influencing decisions. She's made some serious accusations against me without proof, claims of harassment, hostility, implying aggressive behavior. Now, to clarify, I've never engaged in violent or hostile behavior towards her or anybody on the property or anybody that she's accused that I have. Requesting repairs, raising concerns about mold, and asserting my rights is not harassment. Yet, these false allegations, which have been completely hearsay, have been repeatedly allowed into the court record. Finally, the last possibility is questioning whether there's potential undue influence at play. Now, public information indicates Anna has considerable local influence and wealth. While I have no definitive proof, it's very reasonable to wonder if influence has caused these unusual reactions from judges, uncommon procedures, and all the escalation I've encountered. On top of this, Anna persists aggressively spending thousands of dollars in legal fees. This behavior appears irrational to most people I've spoken with, unless she feels there's no way that she can lose, like she has a guaranteed win, or that she's above repercussions, or simply receiving very poor legal advice. Regardless of any of these reasons, it's not right. And I believe that the truth eventually will surface. But until then, I'm going to share this experience openly, and you can decide what you think for yourself. In the last 23 years, I've always gone along with my landlords or property managers across multiple cities in Wisconsin, Minnesota, Nevada, California, and Colorado. I haven't had any major issues with neighbors, and when I've had roommates, they were just as great. I've also never had a complaint filed against me or had not even one lease violation or broken a lease. But I've always wanted to live on the east side of the states, and I wasn't too worried about finding a place when I found out that I only had 45 days to do it because my place in Colorado had been sold to a developer. Now, fate has always led me to where I belonged, and I wasn't about to start doubting this now. I really debated between New York, Connecticut, and North Carolina, but between my dogs, my growing interest in genetic research, and a little astrocartography experiment, North Carolina won. And it was by far the most affordable option. But I quickly ran into challenges. I was struggling to find homes with a fenced yard, and every place I inquired about was managed by some property management company, which was a new experience, instead of a private landlord. Now, this wouldn't have been a deal breaker by any means, except most of the companies with the homes that I was looking at had really horrible reviews. On top of that, a lot have required in-person tours before renting, which I couldn't do until I officially moved. Now, because the Triangle is one of the fastest growing areas in the US, people are buying homes, flipping them out, and renting them fast. Now, if you own the home yourself, you can manage it without having a real estate license. But if you want someone to help you manage it, they have to have a real estate license. That's why there's so many property management companies that manage properties here. And with such a high demand for housing, North Carolina allows property managers or landlords to use their own screening criteria, as long as, of course, they apply with the federal and state fair housing laws that prohibit discrimination. But this is kind of a free-for-all system that turns renting into a competition. Instead of just qualifying, renters are essentially bidding against each other for available homes. Some property management companies, however, do implement something called a first come, first served policy. Now, if they claim to use this policy, it means that the first qualified applicant gets the home no matter who applies after. Now, if they state this, they are legally required to follow through. Seattle and Portland actually have laws requiring this policy, but as far as I could find, they are the rare exception. One thing I failed to review before choosing North Carolina was what kind of state it was, landlord or tenant friendly. I didn't, though, because I've never had to. I mean, I've lived in other landlord-friendly states. Colorado is considered one, but I'm going to now have to be adding that to my list for the next time I move. North Carolina is considered a landlord-friendly state. one of the most landlord-friendly in the country, actually. What does it mean when a state's landlord-friendly? It means that landlord-tenant laws favor landlords when it comes to security deposit limits, eviction processes, required notices, and tenant protections. Meanwhile, tenants are often treated as a problem, seen as people who might damage the property or stop paying rent. Now, personally, I agree that states should protect landlords from bad tenants, but I also believe there needs to be a checks and balances to hold landlords accountable, making sure they maintain the property and don't expose tenants to harmful conditions. Rankings vary depending on the source and criteria, but it seems that Texas is by far the most landlord-friendly state. They have no limits on security deposits or late fees, no state-mandated notice to enter requirements, and the eviction process is quick and easy for landlords. Other states that lean landlord-friendly include Indiana, Florida, Georgia, and Ohio. One state to mention is that in West Virginia, it takes it even further because they allow landlords to evict tenants immediately for lease violations. That's a 0-day eviction policy. On the flip side, the most renter-friendly states include Massachusetts, Connecticut, Rhode Island, and California. These states typically have stronger tenant protections, stricter eviction policies, and in some cases, even rent control. But here's where it gets a little tricky, because some landlord-friendly states have renter-friendly cities. That's why it's important to do your research, not just your state, but also your city or even county when looking at rental laws. So, with 2 weeks left before my move, I still hadn't found a place. And I had to face the reality that finding a single home in the Triangle area wasn't going to happen. So I came across a quadplex owned by DeSantis Rentals. She was very kind, responsive, and assured me that I was moving to a safe, quiet neighborhood. I talked to her on the phone for over 45 minutes. I mean, I asked every question I could, but she seemed very genuine. So she said, actually, you know what? I have another unit in the back. It's more private. No one really goes there. And you'd have your own yard, completely private. It is $100 more a month because you're paying for privacy. But I did make sure to ask about safety because this was, of course, really important to me. She assured me that she did background checks on all the tenants, that one unit was a couple with a newborn, and the other one that would be directly next to me was just a young couple expecting with 2 dogs. She said I could put up a fence, and she sent me a video tour of the inside, and the listing photos showed a very clean and well-kept property. Now, there's something significant here because when you sign a lease for the place sight unseen is what it's called, unless there's a as-is clause, and even then it's still hard in the lease, it puts the burden on the person that sold you or talked you into the lease. Everything they say has to be basically represented. It has to be correct. And this is the reason why so many people in North Carolina require you to see the property before you move in. The very first day I arrived, I quickly discovered my landlord had completely misrepresented the situation. Instead of this safe, quiet neighborhood as promised, even the movers warned me, like, you really shouldn't be walking around here alone. The days were filled with kids screaming, music blasting, and the nights were even worse. Parties until 2 a.m. and domestic fights from the property behind me. And when I told locals, like, oh, I live off Millbrook and Capitol, the consistent reaction was, ooh, yeah, that's definitely not a good area. Clearly, my landlord's definition of safe and quiet differed drastically from reality. Now, this advertised privacy that I was paying so much for in the completely private backyard, the yard was actually shared with Unit D, and I could clearly see the neighbor's home behind me, even though she said that wasn't going to be the case. The unit itself had immediate issues. Vents were caked with dust, like stuck on dust. The microwave hadn't even been cleaned out. There was a non-working dryer, and the countertops were like sticky. Not sticky because they were dirty, but whatever they put on top of it, paper like stuck to it whenever I put it on there. And this supposedly maintained backyard was completely overgrown when I moved in. I mean, my legs were covered in these itchy little red bites whenever I ventured outside. And my dogs refused to go out in the yard entirely. And you know those beautiful listing photos? Yeah, those were another deception. The cul-de-sac that this was on was regularly littered with used condoms, dirty diapers, discarded underwear. I mean, it honestly made me fearful to even walk my dogs on the streets because I didn't know what the heck was going to get on their paws. But most importantly, rather than a nice young couple with 2 dogs next door, I actually found 5 people living in a cramped 2-bedroom, 1,100 square foot unit that was directly attached to mine. It was the expecting couple, as she said, father-to-be's mother, stepfather, and then his brother, a husky, 2 small mixed breed dogs, and 3 cats. One thing that she failed to tell me was that the outside area for their dogs was literally next to my front door. The dogs were left outside for long periods of time in the intense North Carolina heat because I moved there in May, and they were confined to this small, 6x8 pen, which had a kennel in it. And they used that as their main source of exercise for a husky that's less than 2 years old. I never once saw them walk their dogs. They did take them to the off-leash park at times, but most of the time, the dogs got no exercise, and the water that sat outside was rarely changed. And when they would take the husky out, they often left it outside as a source of punishment. And so it would just sit outside and cry, which would break my heart. And then, of course, the smaller dog constantly barked, and this caused my own dogs to bark and to respond to all of this very anxiously. But I regularly would try to provide fresh water for them or give them treats because I was deeply concerned about their well-being. It was actually very stressful, and it forced me to consistently contact the neighbors directly to have to bring the dogs inside after a period of time. Now, after 2 weeks of this, I finally confronted Anna. And of course, she acted completely shocked. She insisted that, she didn't know about the extra people living there. And instead of getting rid of these extra occupants, that was a violation of the lease, she's like, I'm going to let them stay till the end of summer. Now, even though this was mid-May, and I was not very happy about it because it just resulted in more noise. And the situation did improve for about 2 weeks, but then it came back even worse. And this was a consistent back and forth between her and them and me. But these talks, she never enforced any violations, which should have outlined on the lease. She also claimed that she was sending her assistant out weekly, but the assistant wasn't a property manager. She didn't hold a real estate license, and she didn't know any of the lease rules. So these problems just continued, and it was significantly impacting my mental health and work. I was very upset about the fact that she didn't inform me about any of these things before I moved in when I specifically had asked her about it. Now, after 2 months of this, and I did so much. I tried to work with her. I tried to tell the neighbors that I would take the dogs and watch them myself, but that didn't help. Things escalated beyond what I had anticipated, because on 4th of July weekend, leading up to this, the weather in North Carolina, we were having these excessive heat warnings, and they were still leaving the dogs outside. Dogs should not be left outside in excessive heat warnings for maybe 10 minutes max. And I set a rule limiting the dogs to 5 minutes outside during these heat warnings, but this caused a whole new problem because I started hearing distressing yelps and cries from the dogs through my walls. And this was on the 4th of July. I was freaking out. I mean, it sounded like the dogs were being attacked, caused severe anxiety for both me and my dogs. I couldn't even sleep that night. I thought that the dogs had gotten hurt. And so I urgently texted Anna, but I, of course, received no response. Then it happened again the very next day, and I couldn't take it. I immediately went and confronted the neighbors, and I discovered that the husky had supposedly attacked the smaller dog. And they insisted that this was unusual behavior. But it's not really that unusual because by now we had 8 people living in a 2-bedroom unit. That many people living in a small unit, heat, cramped conditions, lack of proper exercise. It's pretty clear of why tensions had risen among the dogs. So after another urgent message to her, Anna finally responded, promising to address the issues with another talk. Now, I told her, this isn't severely impacting my mental health. I even told her why. I gave her the backstory of what I'd been through so she could understand why. And I clearly stated, I could not remain under these conditions if things didn't improve. I didn't want to leave. I just moved across country. I didn't really have the energy or the resources to do that. So I tried to give the neighbors another chance. I even, again, helped them to watch the dogs, but they dismissed it. This environment just became too unbearable. I was getting sick all the time. I was having migraines. And I also wanted to know what else she misrepresented to me. So I started doing some digging and discovered some really disturbing discrepancies in what my landlord had initially told me about the neighbors. I'm not going to go into what I found, but it's enough where I was not okay with the fact that she'd been sharing with them that I was complaining. She didn't conduct background checks on the extra people living there as promised because she claimed to put them as authorized guests instead of tenants, which actually contradicts North Carolina tenant laws and the lease agreement that they signed as tenants. Now, feeling unable to cope with this ongoing stress and health issues, I gave her a 60-day notice because that's what it said on the lease on July 8th. However, Anna refused to release me. Instead, she stated I could leave if I wanted to pay an additional 3 months rent, so $5,000, claiming that she needed time to upkeep the property, but she felt like she was giving me a deal because my lease term stated that if I broke the lease, I'm responsible for every remaining month, and I still had 10 months to go. But the difference is that that violation cannot be enforced if I signed the lease under false pretenses. And with my landlord continually dismissing my legitimate concerns, I was messaging her, I was telling her about the law, and she just ignored me. So I had no choice but to escalate the matter legally. And that's when things got messier. Now, if she had simply just let me out of the lease, it wouldn't have cost her anything. It would have remained a single issue because at that time, I wasn't fully aware of my rights or any other applicable laws because I've never had to. My understanding was rooted in consumer law, thanks to my degree in consumer science and previously successful experiences that I've used applying it. Now, although landlord-tenant laws and rights clearly apply here, the lease is fundamentally a consumer transaction. So consumer and contract law apply as well. Within a month of me giving that notice, this evolved rapidly from a straightforward case of misrepresentation to one involving discrimination, retaliation, warranty of habitability violations, and defamation. Now, each of these violations fall under a distinct legal category, each with specific remedies and procedures. Depending on the nature and complexity of the damages, these violations can be pursued through various courts or agencies. Now, I'm going to explain this further so you understand what your options are if you're facing a similar situation. But first, I'm going to briefly summarize what else has happened during this month prior to my small claims hearing, so you can clearly see why I took the actions I did. Again, this is going to be a very summarized version of this. But the first action I did take was to try to find a lawyer. I figured if I could get one to represent me, this could be squashed easily, but it literally wasn't in my budget. Now, every state has some kind of form of legal aid that's supposed to help represent you if you can't afford it, but you have to be pretty much at the poverty line. And in North Carolina, you have to actually be facing eviction or legal aid can't help. That's not to say they don't try, but the system is extremely underfunded. And in my personal experience, they gave me incorrect legal advice and then tried covering their tracks instead of admitting the mistake when I caught it. They also recommended the Attorney General's office, though, stating that they would handle it for me if I wanted to file a complaint. Now, technically, this isn't true. Okay, the Attorney General's office doesn't fight cases for people. What they do is mediate. They look into complaints and they try to get both sides to work out a solution before things escalate to the courts. So that's what I did first. I filed a complaint with the Attorney General's office. Now, this investigation only took a couple of weeks, but the result was it being dismissed, stating it was a personal matter, not a business dispute. Because Anna had told them, because her personal name was on the lease and the rent went into her personal checking account, this wasn't a business issue. Now, immediately I knew this was like complete bullshit. Not only does she advertise as a business, but renting out property is commerce. And by law, that makes it a business. Now, even after proving this, then it was dismissed due to a factual dispute because stating that what she submitted was fact, despite the evidence clearly showing otherwise. I mean, I even sent them the deed for the property that's registered under her business name. What fact does that dispute? In addition, I also reviewed the evidence that the case specialist had provided for me because they have to give you all of that. And I saw that my landlord had thanked her for speaking with her on the phone. They're not supposed to be able to do that. I'm supposed to be privy to all correspondence because I'm the complainant and I have no idea what they discussed. Not to mention this woman refused to call me back. And I wanted answers to why this happened. They're supposed to help, not reward misrepresentation by refusing to fully investigate. So I started calling the Attorney General's office pretty much every day, trying to get a supervisor. Nobody would call me back. Now, I did get a chance to speak with a couple of other case specialists where one was actually really shocked. And she told me that they are actually required to handle all landlord-tenant disputes, regardless of where the money goes. She said the complaint should have been reviewed. Now, this helped me actually a lot because at least I felt justified in my concern that there's something weird going on. But she couldn't do anything. So she gave me the manager's information, which I never heard back from him. But I did eventually hear back from somebody 5 weeks later. And this was an attorney that was part of the Attorney General's office. And they couldn't give me a valid justification of why the complaint wasn't fully investigated. She claimed that it was just an error, that the real issue of why they couldn't handle it was that they handle habitability issues, not reasonable accommodations, which is what my complaint classified as. And I should file a complaint with the North Carolina Human Relations Commissions for discrimination instead. However, I did report Anna to the FTC for false advertising. This is the Federal Trade Commission. because you are not allowed to advertise the business and then change that to circumvent responsibility. They won't do anything, of course, unless multiple complaints are filed against her. But you know what? It starts with one. I also reported her to the IRS because business transactions aren't allowed to go through your personal checking account. I didn't do this out of retaliation, but I did this to ensure she couldn't use this excuse again, especially if we were going to court. I also gave her one more chance to settle things out before I filed this complaint with small claims, but of course she ignored it. So I went online, filed the small claims complaint, and served her. I also informed her I was looking for other places, and I made it clear that if she tried to block me from renting somewhere else, I'd file a complaint for retaliation. Now, she completely disregarded this warning, a pattern that would continue throughout our dispute. So while searching for a new home, I did actually find the perfect home in Cary. It was less than what I was paying there. It was in a very safe and quiet area. It had a huge yard, and it was fully fenced for my dogs. Now, I applied first. I saw it first. I passed all the checks, and I was confident, like, I'm going to be approved, man. There's no other way. But then the rental agency contacted Anna for a reference. And suddenly, my application was denied due to her unsatisfactory reference. Now, I have never been denied housing before, ever. This was devastating and clearly retaliatory, which is a violation of the Fair Housing Act. So I promptly sent her a cease and desist letter demanding that she corrected the action because they said that they would give it to me if she called back and said that what she stated wasn't true. Now, this is what I learned, that she'd hired an attorney, Frank McGraw from Brady Boyett Law Firm. Now, she denied any wrongdoing, claiming that she only told them I was in a lease until May of 2025. But the agency specifically stated that she gave me an unsatisfactory reference, which meant that I wasn't paying rent on time or that there were some kind of lease violations, which I had neither of. So Anna and her attorney, Frank, created a lease violation regarding expired license plates, which, yes, would have been a violation of my lease, but not in my case because my tags were actually from Colorado and I was in the process of the title being transferred to North Carolina, which takes 6 to 8 weeks. So it actually did not count as a violation. Now, all of a sudden, she's mentioning this. And so I asked, why are you doing this now? Now, she claimed that she learned about this because the neighboring unit, the one I was having problems with, called her and told her. And I found this really suspicious. They actually do have expired North Carolina plates, which that actually does violate the lease. I asked, did you also send the neighbors a violation notice the same time you've sent it to me? And her attorney dodged the question. Now, what likely happened, I don't know for sure, but this is what I'm going to assume, in my opinion, it is that she needed something to support her bad reference. So she called the neighboring unit, asking if I was engaging in any lease violations. Now, by the way, this is also a violation of the Fair Housing Act because it's creating a hostile living environment through surveillance and selective enforcement. So she forced my hand. I filed a discrimination and retaliation complaint with the North Carolina Human Relations Commission. And I ended up losing that perfect home because she refused to take her reference back. But I was stuck. I felt like I was being held hostage at this place. And I realized like I would be forced to move into an apartment or a place that didn't require landlord references. And this was a big deal because my dogs have never lived in an apartment. And this was going to be a very rough adjustment to noise and possibly not having a yard. Also something that they've never been without. And they're 7 and 9 years old. Now, I know you are probably thinking like, okay, well, why did I put her down as a reference? Because there would have been a lapse in my housing history and I'm an honest person. And if questioned, I would have been denied for not providing accurate information. Besides, under the fair housing laws, I'm not supposed to be denied if I can prove that what her actions or her reference was in retaliation, which I did. I provided this proof to RPM Wake County, who still denied me. So I filed a complaint against them with the Real Estate Commission, which is another agency that, of course, refused to enforce any action despite it being a clear violation. But it did provide me with a copy of the reference that she gave later in my case. So it shows that not only did she and her attorney straight up lied to me, but it was also defamation because she stated I did have complaints against me, which I did not. And she made it seem like she was suing me, not me suing her. And then in all caps, she wrote, "Do not accept this application." Okay, she can't do that. But here's the irony and another pattern throughout this case, because it seemed like every time Anna resisted or misrepresented a situation, karma kind of stepped in and something else would happen. So this past summer was extra rainy in Raleigh, I guess, and the parking lot started to flood during rain because the drains in the lot were completely covered in dirt. I mean, it probably would have stayed like that if it wasn't for the fact that a leaking pipe started pooling right next to my, of course, parking spot. The repair actually took a full week to fix, which, according to Raleigh Utilities, that is supposed to be fixed within 48 hours. But during this time, it rained again, flooding the parking lot and forced me to park down the street. Then I had to wade through over 2 feet of water, carrying over 8 grocery bags just to get to my apartment. Once the drains were properly cleared, the lot didn't flood again. Then came Tropical Storm Debbie, which brought about 5 straight days of rain, and water started leaking into my apartment through my fireplace. Now, this was clearly an emergency by her own definition, yet she delayed, of course, and responded and downplayed the issue, which was unlike her from prior experience. But eventually, she had to send a certified chimney inspector out. But she instructed him not to discuss any of the findings with me. When you rent a place, it is your home, and the landlords are required to inform you of issues affecting your property. They cannot conceal information for you. Now, even though she tried blaming it on the storm, claiming it was a hurricane at first, I'm like, it was a tropical storm and it wasn't that bad. Like, there was no other damage. Nothing happened. It was revealed the water was leaking because the cap is so rusted and the cover that if you even applied a little bit of pressure, they would crumble. That's how badly rusted they were. And it was because that they were never properly installed from the very beginning of construction. Since this building was constructed in 1980, this meant water had been seeping into the walls for 40 years. Also, that no inspection was properly done on the fireplace in 40 years. In North Carolina, humidity, mold grows within 24 hours. And I was extremely concerned about what might be growing inside those walls. But she refused to do a full inspection. And then she hired some poorly reviewed, inexperienced company to supposedly fix it. Now, all of this violates fire code, which in residential housing falls under city housing code. And I told Anna, like, fine, you don't want to fix this properly. I'm filing a complaint with the city of Raleigh Code Enforcement. She then tried to intimidate me by saying, yeah, no problem. I know the inspector. So I filed the complaint with the city. Now, they told me that he was supposed to call me before and not just show up, but he did just show up. And this is about a week now before my small claims hearing. And I definitely wanted to get this inspection done because I could use this in my case. And he was very dismissive of my concerns at first. And then he stated that he could only verify if there was a problem if it rained between 8 a.m. and 3 p.m. on a workday that he was working on. But when I pointed out all the other issues that I'd found, especially the pill bugs, which represent that there's some kind of moisture in the walls coming in that through the fireplace, he said that I needed to file a separate complaint for that, which made no sense. Now, later on, after he left that evening, her attorney then emailed me implying that they were in the clear and that no additional inspections were required because they were supposed to be sending a home inspector because, again, I'm concerned about the freaking mold. I heard back from this inspector the very next day. He had called me saying like, hey, just wondering if I can come out next week to do another inspection and we can discuss about the other problems. And I'm like, according to the attorney and Anna, you said that they didn't have to do anything else, that this was done. I'm going to need you to send me an email telling me that they lied. And he said, no, I'm not going to do that. But I told her that if I suspected any undue influence, I was going to escalate this, and I did. And the very next morning, the inspector supervisor calls me saying that they're on the way back out to my place to do an inspection. Now, during this second inspection, they found 14 code violations, and this allowed the unit to have a case open against her for unfit housing. All right, you guys, so sad thing is that this doesn't even cover half the story, but let's break this down. So let's start with getting an attorney. Like I said, I did try. Now you can use something called the Bar Association's referral service, which is like this form that you fill out online. And they're supposed to help connect you with attorneys who agree to offer consultations for $50 for 30 minutes. Except when I did it, I only got one name, and that attorney told me, yeah, you have a case, but if I wanted his help outlining how to present it or a true consultation, he would charge me $600 and it would be about an hour, hour and a half. I'm like, no. Other people I talked to, though, has had the same experience. Like, the firms do not honor the bar's referral deal. So is it worth trying? Like, maybe, but if I'm being honest, probably not. I also reached out to law school clinics because in other states, like, they do allow you to hire a student attorney that is supervised by a teacher or another attorney. But the problem is that school wasn't in session during this because this was the summer. And also in North Carolina, legal aid is actually funneled through the schools here. So they can't actually be hired for cases unless it's through legal aid, which really sucks because law schools can be a great place to find an attorney that's at least affordable. I did, however, find one law firm that did do a consult with me because they felt really bad for my situation of what I was dealing with and because I was new to the area. They explained my options and walked me through what I could say in court. Now, they also told me that most law firms in Wake County do not take tenant cases anymore, and this is confirmed as I tried. So I decided to represent myself because really, what other choice did I have? And that will be a choice that you will have to make as well. So why did I bother going to the Attorney General's office? Well, because I'm a consumer advocate and the Attorney General is supposed to be as well. I lived in Washington for 8 years, and during that time, the current governor now was the Attorney General that time, and he kicked ass. Like, I even interviewed him for my previous publication, and he kind of showed me the value of the office, but unfortunately, North Carolina has taken that away from me. Now, every state has an Attorney General. They are the top legal officer for the state, and they are part of the Department of Justice. Their job is to enforce state laws and protect the public interest. This includes things like consumer protection, civil rights enforcement, and sometimes housing violations, and representing state agencies in court. The power of the Department of Justice in every state depends on the person in office. Some attorney generals actually do use their office to protect people, while others are more hands-off or politically influenced. That's why it's so important to understand who you're voting for, because your attorney general plays a huge role in how seriously complaints like housing violations or discriminations are taken. The attorney general of the Department of Justice is not above the law. They're just meant to enforce them. However, holding the office, though, actually accountable if they aren't behaving the way they should can be incredibly difficult. Now, in a state like North Carolina, it's even harder. And that's because North Carolina does not have an inspector general, which is an independent agency that oversees misconduct or abuse within government offices. Without that, there is no direct oversight of the attorney general's office unless there's enough public pressure or media scrutiny to force some kind of action. So yeah, if the attorney general fails to act or mishandles my complaint, I don't have a lot of recourse here. And that's a freaking problem, because if people in power aren't held accountable, then who's protecting the public? I'm going to circle back onto this later because my complaint wasn't the only fight with the Attorney General's office or the DOJ. All right, let's talk about discrimination and retaliation, especially in housing. Now, there is something called the Federal Fair Housing Act. This is a federal law. States also have one, but most of them mock the federal law, which states that it's illegal to discriminate based on race, color, national origin, religion, sex, familial status, or disability. Now, this includes mental health disabilities too. Most people think discrimination just means, though, like being denied a home, but there are other forms. If you have a condition that qualifies under the American Disabilities Act, you are entitled to request reasonable accommodations. This can be something like a service animal like myself, or adjustments to your lease or actual property that allows you to safely live in the unit as long as it doesn't cause an undue burden. Meaning you can't ask your landlord to like install an elevator because you need one, but when you got the place, you saw that it didn't have one. Like that would be something that would be an extreme burden for the landlord to put in. And to be clear though, you don't have to use the term reasonable accommodation for your request to be valid. If you're referring to something that protects your mental health or your disability, as long as you kind of indicate the situation or the intent, the law protects it, not the wording. Now, retaliation happens when a landlord or a housing provider takes action against you for asserting your rights. Now, this could be delaying repairs, threatening eviction, initiating eviction, giving you a bad reference, making up lease violations, surveillance against you, all because you filed some kind of complaint or asked for legal accommodation. And here's a very key point, though, to know that retaliation is a separate claim. You can file that complaint even if there is no discrimination, but they do often show up together. Now, if this is violated, you file with HUD, which is Housing and Urban Development, or an FHAP agency like the NCHRC in North Carolina. These agencies are basically hired by HUD to handle complaints locally, and they get paid to do so. Or you could also file a civil lawsuit in federal court up to a year after from when the discrimination happened or retaliation happened. If you choose to take the agency route, though, and which most people do because it's actually going to be faster than federal, they are supposed to finish this investigation within 100 days by statute standards. And if no reasonable grounds are found, they give you this right to sue letter, and then you start the whole process over again in federal court. Now, if you're dealing with issues under something called the warranty of habitability, now this is a basic legal requirement in all states that state that landlords have to maintain rental properties in a livable condition. We're talking about safe wiring, running water, working heat and AC, no infestations, of course, proper drainage, safe fireplaces, all essential things that make a place livable. And they also have to have the property up to code. Now, within this warranty of habitability, there's different levels, but there's also something called intimate dangerous conditions. And those are especially extreme circumstances where landlords are supposed to remake these repairs even quicker. Now, the way this gets enforced, though, is through city code enforcement. Each city should have one. If they don't, or if it's not an incorporated city, it will go to the county. In Raleigh, for example, though, you can file a complaint with the City of Housing and Neighborhoods Department online, and the city inspector will come out and assess the property. Now, if they find these violations, they're going to open something called an unfit housing case against the landlord, and this is going to give you an official report of these violations, which is huge because once these violations are documented, you've got evidence that backs up that warranty of habitability claim. Also, the city of Raleigh gives public access to all of these complaints. So you can look up a property if it's within the city limits to see if that property has had violations. Now, if the violations are serious enough, the city gives the landlord a deadline to make repairs, usually within 30 days. Now, if they ignore this deadline, then the property is then flagged for unfit for human habitation and they get fined, and then they get 30 more days to make the repairs. And if they don't make the repairs, we put like a tag that says unfit for human habitation, and people have to vacate the property. But here's something really important for tenants to know. Now, you have a right to deny repairs if the work interferes with your health, safety, or schedule. They can't bring in a repair unless it's an emergency, right? So for example, if you work from home and can't have loud repairs done during the day, or the repair process could create more risk, like disturbing mold or lead paint or bringing in unqualified contractors, you can refuse access temporarily. You're not required to accommodate whatever timeline the landlord wants. The landlord has to work around you, not the other way around. This falls under the covenant of peaceful enjoyment. This is a built-in right in every lease, even if it's not spelled out. It means you as a tenant have a legal right to live within your home without constant disruptions, harassment, or interference, whether that's from the landlord, the neighbors, or ongoing issues that never get fixed. However, one thing to note is that mold is very tricky. In North Carolina, unless mold is visible or is tied to some kind of structural issue like a leak, the city of Raleigh at least won't step in. Cary won't step in at all. So if you suspect that there's hidden mold, or even if you see it in some areas, you have to actually get a private inspection done and to prove that the mold is toxic, and then take that to court separately to get reimbursed. So if your landlord violates the warranty of habitability, you're entitled to some kind of relief through something called rent abatement. This means that there's a reduction in rent because the unit wasn't fully livable. For example, like if your HVAC system was broken for 2 months and you had water damage, you can argue that you overpaid for the space that didn't meet the basic living standards. Then you ask the court to award you a percentage back of the rent that you paid during on time. And there's no like formula to this. You just kind of make it up yourself what you think is fair. And you can also seek reimbursement for repairs if you made anything out of pocket or costs that if you were forced to stay somewhere else because the unit became uninhabitable. Know that some states allow you to withhold rent if repairs aren't made or if you're in this situation, but North Carolina is not one of them. You do have to pay rent no matter what. Because if you don't, that gives them grounds to evict you. One thing important to know, though, is that even though with this peaceful covenant enjoyment, landlords aren't usually responsible for resolving disputes between neighbors. And a lot of leases even state that directly. So legally, they're not required to step in unless something violates the law or the actual lease terms. And this is where things kind of get tricky, right? Because it was the result of my landlord refusing to enforce her own lease and failing to conduct background checks like she claimed she had. When she misrepresented the safety or the character of the property and then refuses to act when lease violations occur, this is a very different situation and where interpretation of the law is required. Now, before we get into the court system, I'm going to quickly explain misrepresentation and why I originally thought that I had a solid reason to break the lease. Now, misrepresentation is when a landlord or anybody in a business transaction makes a false statement that convinces you to agree to something like signing a lease or buying a car. That could involve like lying about the safety of the neighborhood, condition of the unit, number of occupants, or the enforcement of certain policies. If you had specific concerns and they lied about that, that is misrepresentation. Now, even if they didn't outright lie, like maybe they omitted critical information or said something that gave you a false sense of what you were agreeing to, that's grounds to claim that the agreement wasn't valid. In North Carolina, this falls under Unfair and Deceptive Trade Practices Act. This law protects consumers against fraud, deception, and misleading business conduct, including landlord and tenant relationships. And the misrepresentation doesn't need to be intentional. There was actually case law, Marshall v. Miller, that talks about this. So if a landlord misleads you and it causes financial or emotional harm, you may be entitled to actual damages. And under the statute, those damages are tripled. It's called treble damages, and it's designed to punish deceptive behavior and discourage, of course, from it happening again. But let's just say, for sake of this, that wasn't the case, right? Let's say you just need to get out of the lease because you got a job and you had to move, or something happened where you just needed to go, and there was no misrepresentation. Landlords actually have this responsibility to do something called mitigate damages. They're required to make a good faith effort to re-rent the unit and reduce what you owe. I mean, you may be responsible for some rent, like maybe it would take like a month to rent it out, right? But they can't double dip or let the place just sit empty and expect you to keep paying. So the moment I leave the property, she was required to put up rent. All right, you guys, now we're getting to the nitty-gritty of things. Now, before we get into how to actually file, let's break down the court system, because trust me, it is confusing, especially since a lot of states name their courts differently. In the US, we have two main systems running side by side, state and federal courts. Most housing issues like landlord-tenant disputes will go through the state court system. The federal court usually only applies if you're suing somebody under the federal law, like the Fair Housing Act, or if the case involves parties from different states, or if there's a certain amount of money at stake. Within each state, there are usually 3 levels of court. There's trial courts. This is where your case is going to start and where evidence is presented and a judge or a magistrate hears both sides and makes a ruling. Then there's appellate court. If you lose and believe the judge makes a legal mistake, you can appeal it. This court doesn't look at new evidence. It just reviews what happened in trial and see if they want to reverse the decision. The Supreme Court is the highest state court. Every state has one, even though it may be called something else. I think in New York, it's called actually the Court of Appeals. It's the Supreme Court, but then the Superior Court is Supreme Court. The Supreme Court, though, only takes a few cases, and usually it's the ones that raise major legal questions or conflicts with state law. So in North Carolina, for example, we have District Court, Superior Court, Court of Appeals, and the Supreme Court of North Carolina. And none of this includes the federal system, which is a whole nother track. So when you're filing a housing or consumer case, you are starting at the trial level state court. Now, when it comes to trial courts, there's also a few different levels, especially in North Carolina. Which one you use depends on how fast you need it to be heard, the subject matter jurisdiction, meaning filing in the right court for the right type and the amount of relief that you need in your claim, and of course, personal and territorial jurisdiction, which is filing in the county where the issue happened or where the defendant lives or does business. Let's start with subject matter jurisdiction. Now, this claim type that I filed is civil. So you need to file in civil court, which in North Carolina, civil disputes, there is small claims, district and superior court. Small claims is the fastest and the easiest, but it has the least amount that you can ask for. Now, this is what people think of as like a people's court, right? This is the type of court that you see on Judge Judy. It's just not as dramatic. In North Carolina, the maximum amount that you can sue for in small claims is $10,000. You don't need a lawyer, and that's the point of small claims. Also, small claims is handled by a magistrate, not a judge. A magistrate is an attorney that is trained like a judge, but doesn't have the same authority. Cases are supposed to be heard within 30 days, and they're also the ones that are least complex. You can file for a money award, a summary ejectment, or possession of personal property. Now, here's where I'm going to admit I made a mistake. And honestly, it's one a lot of people could easily make, especially if you're representing yourself. I filed in small claims court because I needed it to get out fast. And I was thinking that if I could prove misrepresentation, the court would release me from the lease. What I didn't know at the time is that the magistrate does not have the authority to rescind a lease, which is the term that's associated with misrepresentation. They can award money, but they can't actually terminate the lease or declare it void. That has to be actually done by a district court judge. Now, in fairness, if the magistrate would have ruled in my favor, my landlord probably would have let me out of the lease because then it's on the record that she misrepresented the terms. But I could file something called a declaratory judgment in district court, which would basically be asking a district court judge to rescind my lease because of the small claims judgment without having to go through the whole trial. again. It still would have been the fastest route. But this is why it's so important to understand not just the facts of the case, but also what remedies each court is allowed to actually grant. And in some states, small claims may be able to do these types of orders. It just depends on how the state utilizes small claims court. But the reason why it's so confusing here in North Carolina is because they use small claims court as the court to process evictions. A magistrate can throw someone out of their home, but they can't undo a lease that was signed under false pretenses. Summary ejectment, which is an eviction, is a statutory process, meaning it's spelled out in North Carolina law under General Statute 42-26. The law gives magistrates the specific authority to hear eviction cases, make possession rulings, and award, of course, rent or damages. But rescinding a lease or voiding one isn't based on landlord-tenant statutes. It's based on contract law and oftentimes to claims like misrepresentation, fraud, or the UDTPA, so the legal foundation is different. Now, if your damages go beyond $10,000 but are under $25,000, or if your case involves more complex legal arguments that require this equitable relief, you can skip small claims and go directly to district court. This is also where you go if you appeal your case out of small claims. Now, this is a much formal process than small claims. And if you're self-representing, you'll need to learn the rules of civil procedure and the rules of evidence, which there's a lot. It also moves slower, but it's supposed to push cases through quickly. This means, though, that you're going to have to know how to introduce documents, call witnesses, object properly. I mean, it's kind of a lot, but it's doable if you're prepared. Then, if your case is more than $25,000 or handles more serious or complex case like discrimination or defamation, that is when you would file in Superior Court. But just know, though, that Superior Court moves a lot slower and it comes with more formalities. So it's not like where you would go for a fast remedy. On top of that, I mentioned personal or territory jurisdiction, which is about location. You have to file in the county where the issue happened or where the defendant lives or does business. So, for example, I currently live in Durham County, and the incident that I'm dealing with happened in Wake County. And that's where Anna's business was registered at the time of filing. That's where the lease was signed and where the property was. So I had to file in Wake County. If I would have filed in Durham County, because that's where I was currently living, the court could have dismissed it for improper venue or jurisdiction. Now, if you're not sure where your landlord's business is registered, you can look it up on the Secretary of State's website, which I put in the resources. And if you're suing an individual and don't know their current address, voter registration records can sometimes help confirm where to serve them. Either way, it's more about where the incident happened if you have no other recourse. Now, if you're dealing with a company or a landlord that owns properties in multiple states, jurisdiction works a little differently, but the core rule is still the same. You file where the incident occurred. So if you're renting from a national property management company that owns apartments across the US, but their headquarters are, let's say, in Texas, and the unit you rented was in North Carolina, even if the business is based out of state, you still file the case in the county where the property is located. Still need to properly serve them, which means serving their registered agent, usually listed with the secretary in the state that they're at or where the property is. The agent is legally authorized to receive lawsuits and legal notices on the company's behalf. Because if you serve the wrong person or use the wrong address, the case could get tossed. And when it comes to serving, which means officially delivering them a copy of the lawsuit so they know they're being sued, is another thing that can get your case thrown out if you don't do it properly. So, for example, in Wake County, you can file your small claims complaint online, actually in most counties in North Carolina. But even though you file it online, you can't serve it online. You can't just email it to them or hand it to them yourself. It has to be done legally through the sheriff's office, which is probably your best option, a processor server. You know, that's the person that you always see on TV where they're like, you've been served, or by certified mail with a return receipt. If you're in a county in North Carolina that has the eFile and serve system, which allows you to file everything electronically and serve future rulings, now I actually highly encourage you to do this. It actually gets you to quicker access to these notices and filings, but you do have to file a notice with the court saying like, hey, I'm going to accept electronic filing. Please notify me of everything via electronic. Then you also have to email the opposing party or opposing counsel and let them know too that you want to be served via this eFile and serve, because then it bypasses them the ability to mail it to you. Because when they mail it to you, it actually extends timelines by 3 days. And also, attorneys are purposely going to do this as a way to deter you from getting the filing on time, especially if you're someone like me that never checks their mail. But once you notify that opposing party and you say, this is how I want it done, they are required to serve you that way. They cannot use the mailing excuse anymore. In fact, you can actually use that against them if they improperly serve you. Okay, so in North Carolina, your court date should be within 30 days if you filed for small claims court, which they're actually going to mail that to you, or you can check the e-portal docket online. Your court date should be there within a week of filing. Small claim hearings are usually quick, sometimes just 10 to 20 minutes, but they aren't limited to that. Okay, you're allowed as much time as you need to present your case. In my case, my hearing ended up taking over an hour because so much had happened. And that's also why it's very important to document everything early on, because Anna actually preferred to only talk on the phone. But later, I made sure to shift all communications to text and email because those are actually considered admissible evidence in court. Anytime you're dealing with any kind of legal issue, just document it. Avoid phone calls if possible, unless you're in a one-party consent state like North Carolina, where it's legally able to record conversations without telling the person. But in a lot of states, though, you actually have to get the other person's permission to record something. So you just have to check the state law on that before you actually hit record. Also, though, keep in mind, now verbal agreements in North Carolina, not all states are like this, so make sure you check. But North Carolina, technically, you could rent a place if the lease term is under 3 years just by some kind of verbal agreement. You actually don't have to have a written lease. You just have to have some kind of proof to back it up to say that it was stated. Either way, written communication, of course, is always your safest bet. Now, when it came to my hearing, I was prepared, like binder level prepared. I had a 1-inch binder filled with communications, emails, photos, and an email from the city of Raleigh showing that they had opened that case for unfit housing. I color-coded everything with tabs, organized it in the exact order I planned to present it. I was a plaintiff, so the burden of proof lays upon me. Also, keep in mind that you don't get to see the defendant's or the other side's evidence ahead of time. And they don't have to file something called an answer to your complaint like they would in district or superior court. So you walk in completely blind, and you'll need to be ready for any possible defense they might try to throw at you. Also in North Carolina, and I imagine in most places, you'll need to bring 3 printed copies of your evidence. So one for yourself, one for the magistrate, and one for the opposing party. Now, if there is more than one opposing party that has more than one attorney, you'll have to bring a copy for them too. Okay. Now, don't send anything ahead of time. And honestly, you don't want to. Because, in my case, I had no idea what Anna's defense was actually going to be. I kind of treated this like a slam dunk since I had that email from the city. To me, that's, again, black and white. Like, under the warranty of habitability, you have to keep the place up to code before you can rent it, and she didn't. I should be able to get some kind of retribution, and there's no disputing the fact. Even the attorneys I spoke with and my friends that are attorneys in other states assured me, like, my case was pretty solid, and I didn't really have to worry about anything shady happening. Like, they're like, it's not like what you see on TV. I mean, the law is the law. They have to follow it. But small claims hearings are not recorded. There's no transcript, no audio, no way to review what was said or how it was handled. Now, I didn't know that going in, and if I had, I would have asked permission to record. I don't know if they would allow it, but at least you could ask to see. In most states, attorneys are strongly discouraged because the whole point of small claims court is that it's supposed to be informal and accessible for people who can't afford legal representation. But again, in North Carolina, attorneys are allowed, and this is a real problem. They don't even have to file a notice of appearance. That means you may not even know that your landlord has hired an attorney until you walk into court. If the magistrate doesn't mention the attorney in judgment, there's no official record saying that they were even there. And that's kind of ridiculous because let's be real, magistrates are attorneys. They were trained as lawyers. So when you're a self-represented tenant and the other one shows up with an attorney who knows the system, who might and most likely even knows the magistrate personally, or has been in that courtroom 100 times and seen the magistrate, how is that fair, right? They can start throwing legal jargon around and obscure procedural rules that you were never expected to know. Small claims isn't supposed to require you to fully understand the rules of civil procedure, but if an attorney starts manipulating the system, you're already at a disadvantage. It creates this inherently prejudicial environment and no one's tracking it, at least in not North Carolina. That's not justice, okay? That's a loophole that favors people with money and connections. But the court obviously isn't very concerned about it because they make it easy for you to appeal out of small claims court. There doesn't have to be any specific reasons. You have 10 days to appeal it for any reason whatsoever, making small claims basically just a first step, whether it's a pointless step. I guess that kind of depends on you, but on what you decide, because I haven't seen a lot of success in the cases that I have researched, but I'll get to that later. But because it's so easy to appeal, it's also the reason why a lot of LLCs or corporations will have an attorney in small claims, because in North Carolina, if you are an LLC or a corporation, you actually have to have representation in district or superior court. You could not go pro se. In small claims court, you are allowed to, but not afterwards. So if they suspect that you're going to appeal, especially if their case is weak, they're going to try to get an attorney right away, because they will want one through the whole process, or they're going to have one just to intimidate you and to scare you out of appealing. Even in my own case, though, even knowing what I know now, I wouldn't have changed the process. I still would have proceeded with small claims court, because it kind of allowed me time to learn the system and go through this kind of trial and error process. I also believe things happen for a reason. Like, I really do believe that I was meant to experience all this so I could bring awareness and expose this process, because obviously it was needed. One thing, though, I do want to make you aware of is how attorneys behave and what you need to prepare for if you're going to go pro se. Attorneys are meant to follow these professional code of ethics. There are certain things that they're not allowed to do, but that doesn't mean they won't. I don't know, honestly, if it's the state or this is how typical attorneys act, but I will say the two that I have dealt with during this case, in my opinion, have disturbingly acted in bad faith. And I have filed grievances against both of them. A grievance is filing a complaint against an attorney by saying, hey, they're not following the rules. They shouldn't be an attorney in this state, right? Because an attorney is not allowed to lie for their clients. They're not allowed to lie to the court. And they're not allowed to lie to you. They're not supposed to file improperly or violate rules. This could potentially get them suspended, or they can lose their license if the bar finds them accountable. But in North Carolina, at least, this process takes forever because the bar has so many grievances, which is kind of telling. But hey, you know what? At least their bad tactics have allowed me to warn you what to prepare for. So Mr. McGraw tried to have my case thrown out. 5 days before the hearing, he filed this motion to dismiss, stating there was no claim to which relief can be granted, and he cited Rule 12B, a rule that only applies in district court, not small claims. This was a completely improper move. He definitely knew this, because in small claims court, a case cannot be dismissed based on the contents of a complaint. The only reason you can dismiss a case in small claims is if there's a failure of service or the court is in the wrong jurisdiction. Now, I did file an improper filing to call that out, but the magistrate never ruled in the motion. No judge ruled on it. And of course, the attorney never withdrew it. Then during the actual hearing, he tried it again, this time invoking Rule 15A, claiming that I had amended my complaint too many times. But again, that rule doesn't apply in small claims. In fact, you're allowed to amend your complaint, or as the statute states, perfect your complaint how many times you want before the hearing. And you could even bring an entirely new version of a complaint the day of. The court has to allow it. But the magistrate did not acknowledge to the attorney, hey, that's not allowed. Instead, he says to me, you know what? I'm going to do you a favor and allow you to argue your case. Like, he's like, why did you amend your complaint so many times? I'm like, oh my God, I didn't change it that many times. I'm like, it wasn't even different. It was just changing dollar amounts, basically. And I was very nervous and exhausted when I actually got to court that day. Because, oh, and side note, make sure you dress appropriately. You have to wear business attire to the court. I mean, you don't have to get a suit, but you should at least look very nice. I mean, don't show up in jeans and a t-shirt, okay? Or your pajamas, even though I probably would have if I could have. Now, I had only gotten an hour of sleep because I was up all night prepping the evidence and the case. I just wanted to make sure I had done everything right. And I thought I did. And I even told the court, like, hey, just let you know, I have generalized anxiety disorder. I get very anxious. So if I speak too fast or something seems off, and I wasn't doing this to like get sympathy for them, I was just trying to warn the magistrate. So when you arrive though at small claims, you're going to be set into a specific courtroom and there's going to be multiple people in there. And then they're going to do this roll call and then they go, you know, case one by one to see who's there. And when I arrived, I mean, it was full. And when we did the roll call, like our case was called someplace in the middle. Now, generally cases are heard within the same order that roll call is, but they don't have to do it this way. And the magistrate certainly did not. In fact, he put me actually dead last and made sure that nobody else was in the courtroom that could actually witness the case. There was only 2 people left and they didn't speak English because they were waiting for an interpreter. I found this a little odd, but you know what? I shrugged it off, whatever. I presented my case. And when I was finished presenting, Mr. McGraw got to cross-examine me, and a lot of questions that were asked were completely irrelevant. And I didn't know I could object in small claims court. And that's on me. You know, I'm going to own that because I could have. I definitely should have. But I also expected the magistrate to kind of step in, and he didn't. I mean, that's supposed to be part of his job, to ensure that pro se parties aren't badgered or manipulated. But instead, he just watched and let it all happen. Then Anna testified, and that's when things just kind of went off the rail. Now, she didn't come with any evidence. There was no documentation, no photos, nothing. She just had her words. And she painted herself, of course, as this perfect landlord, claims she's never had a problem with the tenant before. And of course, then framed me as this angry, impossible to please nightmare. She even said that her assistant was too terrified of me to come and testify in court that day. She was going to come, but she was afraid of what I would do to her. And that all the tenants also were afraid of me. I was stunned. I'm sorry, wait, what? None of this was supported by evidence. This is all hearsay. And yet it was allowed into the record. So when I was able to cross-examine her, I asked her about the fact of, okay, if you're so afraid of me, did I ever threaten her? Have I ever been violent? And then she would say, no, but who knows with someone like you? She always had these loaded phrases. And then when I would try to challenge that, the magistrate would shut me down and said the questioning was irrelevant. And I'm like, I'm sorry, I have the right to defend myself. I can prove that her allegations are false. She gave me a gift. You thought I was a great tenant up to this point. And so this was all news to me, but he just completely ignored that. And not to mention, as for her assistant, I've had 2 interactions with her. One was when I moved in, nothing happened. Second time was because she had texted me about something, I was offered to help her find a job. I don't have no idea where this whole thing came up with her assistant, but okay. Now, at one point, the attorney actually brought up settlement offers, which under the rules of evidence aren't supposed to be introduced in court. But again, the magistrate allowed it. And he lied about how many settlement offers even there was. Every time I had tried to object or correct the record, I was silenced, even though that they had openly violated the rules of evidence. The only other defense that they tried to play was something called constructive eviction, which again, unless you are super advanced in real estate law, you would not know anything about this. It is not in the Residential Renters Act. It's not listed in any tenant right books that you get or a guide. And even if I was to claim it, I would still have to be in court. So honestly, it doesn't really matter. So in North Carolina, constructive eviction occurs when the landlord's actions or inactions makes the rental property uninhabitable or significantly interferes with the tenant's use of enjoyment, and it forces them to leave. This is essentially the landlord breaching their duty under the lease, rendering the premises untenable. But in my situation, that wasn't the biggest problem. The problem was that I was asking for reasonable accommodations, which is even separated from this. The whole warranty of violation of habitability only became a severe problem within those 30 days. I didn't even know about this. And then of course came the worst part, okay? So at the end of the hearing, the magistrate looks at me and says, you know what? You just seem like a complainer. You're not happy with anything. I mean, look at what she's done for you. When things don't go your way, you report people to their bosses. You obviously have a problem with authority. I was floored. Not only was this completely uncalled for, it had nothing to do with the legal merits of the case, he had no right to speak to me that way. He does not know anything about me. I had 23 years of perfect rental history. I followed every rule. I did everything right. I showed up with evidence. She showed up with nothing but stories which the magistrate obviously would have known that they were untrue, because if what she was stating about me was true, that is actually grounds for evictions. So if I was the magistrate, I would have been like, oh, if she was that bad, then why haven't you just evicted her? But guess what? He didn't. And that should have been his clue right there, which makes it super suspicious. And also, somehow though, I lost. He claimed that my evidence wasn't enough. What else do you need? There was literally, unless you lived in the place with me, there was no other way I could prove this. He even made some strange comment about my amended complaint, saying I should have withdrawn this. Why did I even bother filing it? And if all this stuff happened in between? And I'm like, are you serious? Because then I would have to wait another 30 days. Again, I'm allowed to change things. So that alone kind of raises questions. I walked out of that courtroom shaking. I had no way to challenge what was said in there. No transcript, no accountability. But I guess I did have 10 days to appeal, and I knew I was going to. So even though the magistrate ruled against me, though, this case did allow me to get out of the lease, not because, of course, the system worked, but because I used her own lies against her. Now, right after the hearing, I was honestly emotionally wrecked. I couldn't work for 2 days. I was sick. I was just so devastated. What happened in the courtroom just felt so unfair. It was disoriented. And the way the magistrate spoke to me without any evidence or justification has kind of triggered this really deep-seated thing in me. I don't know. It actually helped me come to terms with, of course, being on the spectrum, which is something I talk about in Lesson 9. And I only became aware of recently and as a result of this case. Now, people on the spectrum have this heightened sense of justice. And when the system fails, it just doesn't compute. Instead, we're going to demand answers because it kind of breaks something. The next morning, the attorney emailed me acting like, of course, they had won, and offered to let me out of the lease without financial penalty this time, but only if I agreed to give up everything else. My appeal, I had to rescind the AG complaint, I had to pull out the discrimination complaint, and then they wanted me to sign a confidentiality that I could not tell or share my story or give any reviews. I responded quickly, you haven't won anything. I have 10 days to appeal. Then something happened. Like I said, karma, maybe, I don't know. But I noticed that the fireplace damper, which supposedly had been fixed, was broken. It wouldn't close. So I took a video of it. Now, rain was expected that weekend. And if it came through that chimney, that would have been an intimate, dangerous condition. But guess what? My landlord had just flown off to Europe like she usually does for months at a time. And our assistant wasn't a licensed property manager, so she couldn't take care of it. So I emailed the attorney, and I also took the opportunity to get documentation of how they lied in court. I said, oh, by the way, can you send me all the records of those settlement discussions that you mentioned in court? Now, instead of denying this, he actually doubled down by forwarding me one and then forwarding me a response to something I sent him, which proves he stated that in court. So I sent that evidence directly to the bar as part of his grievance. Then I gave them a choice. I said, listen, this damper has to be fixed now because this is going to be an emergency. If she was refused to do it, I would declare constructive eviction because now the unit is unsafe to live in. I also reminded them that I filed for reasonable accommodations over 2 months ago and she denied me that. And now I have this active complaint, and that the assistant couldn't come by because the landlord had claimed in court that she was so terrified of me and that she couldn't even testify. If that was true, she could not help out with the repair or enter my home. And if she did, and she was also not afraid of me anymore, that would show that she lied under oath. Said, or you could just approve my second request for reasonable accommodations and I will vacate without penalty and no agreements to withdrawing of anything. And guess what? They agreed and acted like nothing had happened. Now, of course, they didn't admit fault, but the lease was terminated and I was out. Now, of course, to cover up her lie, and because I mentioned perjury, she actually had the police come to my place during my move-out inspection because the assistant had to be there because she was out of the country. Now, this was so inappropriate. It was retaliatory and deeply disturbing, but it also confirmed the narrative that she had created and just proves kind of how far she was willing to go to hold her version of the story together. But in the end, I got out because I knew how to hold her accountable, not through force, but through facts. After I got out of the lease, I only had 48 hours to find a new place to live, 2 dogs, and a requirement for a yard. This is not easy. There are only 3 complexes in the area that had apartments. There's Bexley at Briar Creek, Bexley at Triangle Park, and then the Corners at Briar Creek. Bexley at Triangle Park, I liked the area and I had fewer bad reviews and they offered bigger yards. I would have gone with the Corners, but because it was newer, which is what I should have done, but the units are so much smaller. When I toured Bexley at Triangle Park, I said, listen, hey, has there been any water damage, mold, anything I need to know because I'm in this situation right now and I cannot repeat this. Oh, no, the unit's great. It's fine. So I applied, got approved immediately because I didn't need a reference from her, paid the deposit, and then I submitted my dog's paperwork for service dogs, and that's when everything started again. What is going on, North Carolina? I got an email from them asking me to fill out a medical form for my dogs because they've never dealt with service animals before. Now, I sent them the actual HUD guidance letter stating that they're not allowed to ask for that. They are allowed to ask for 2 questions, which I answered them, and that should have been the end of it. Instead, they kept pushing. They said it sounded like an emotional support situation, not a service animal, and that I needed a medical provider form or I would have to pay rent and the deposit. Now, let's be clear, this is straight up illegal. They cannot do that. I spoke to a few attorneys about this, and there's so much confusion between this emotional support animal and service animal that no one had a clear answer, even though, again, it is literally laid out in HUD. This is what you're allowed to do. This is what you're not allowed to do. It literally says you're not allowed to ask for documentation on service animals. And I gave them documentation. I gave them my dog's certified training. Okay. And that should have been plenty, but I didn't have time to go back and forth. And I had 48 hours to move. So I just said, I'm not filling out that medical form because I can't. It would be fraud. I will just move in, pay it, and file the complaint later. Now, as I was dealing with that, just 3 weeks or so after I moved in, I noticed that mold was forming on top of my ceiling. I found areas of water damage, the closet that I didn't see, and then also on the wall inside the spare bedroom was growing mold. Well, guess what? Then I find out that there had been water damage in the unit. I was not happy. They also came in and tested the walls because the place was like so humid, which they confirmed that there was high levels of moisture inside the walls, okay? On top of that, this hallway that was connected to my apartment on the other side through for these garages, usually the door was closed, but I noticed it open one day and I looked in and there was black mold just covered. I wanted to take pictures of this and I had a hard time breathing. So you got to imagine when it starts growing on the outside of the wall, it's already grown in the inside of the wall. I told them like they need to come in and test to see if this mold is toxic. And they said, well, we're not going to do that, but what we're going to have to do is tear out the ceiling to dry it out because there was also another leak happening because the people above me, AC unit, I guess had flooded, causing this water to come down and they would have to tear the ceiling out to dry it out. And I'm like, you're not coming in my apartment and tearing out a ceiling while I'm freaking working. Like, what is going on right now? And then they changed their mind and said they were just come and clean it off and paint over the damage. And I was like, no, absolutely not. I literally just went through this. I am not doing this again. I said, you were going to let me out of the lease and you're going to refund my rent. At first they were like, yeah, no problem. We'll let you out of the lease, but we're not refunding your rent. And they said, oh, there's no mold. I mean, because at this point they had painted over it, which they had in the hallway, but not in my apartment. But what the manager didn't know is that I recorded our entire conversation, which included her admitting that the mold was really bad. They didn't know where it came from. They don't know how it happened. All about the previous water damage in the unit before I moved in. Bam, misrepresentation, plain and simple. And that's what I told her. I said, it was up to you. I go, you obviously didn't realize that I recorded our conversation. So we can either handle this quietly, you can refund my rent, my pet deposit, everything that I've paid and let me out, or I'll take you to court too, because at this point I just didn't care. Well, right after that, they agreed to fully refund everything and let me out as long as I moved out at the end of the month. So again, I had only 2 weeks to find another place. I'm just like, are you serious right now? So this time around, I picked a brand new complex. So I did not have to deal with this. Nobody's lived in the place before me, but I had to sacrifice the yard for the first time in my poor dog's life. And honestly, it was very upsetting. And it made me really resent Anna even more because she had taken that good home away from me. And because of her, I was being forced to move again. And the money and the time that it was costing me was unbearable. But I will say this, how Bexley handled it is how a business should handle a legitimate complaint. Like, dude, the evidence was stacked against you. They didn't try to double down. They didn't try to lie. They didn't try to go to court or attack my character. They handled it. And then you move on. And that's what Anna should have done. But she chose to fight and she's still fighting. But you know what? This is what happens in this state, though. Situation at Bexley, it's disturbing that a corporation will just paint over a problem and risk getting tenants sick than actually doing the right thing and spending the money to get the property properly repaired. And that's why these places go to shit and you end up with poor reviews, mismanaged properties, and tenants that are unhappy. And you better believe I told all of my neighbors about what happened. So I said, you know what, whoever moves in after me, you should let them know too. I feel like I'm pretty much running on fumes right now. So I'm sorry if my voice is starting to get a little raspy because I haven't even explained the worst of it yet. Now, after getting out of my lease, of course, even though I was done with the apartment, I wasn't done with what she had done to me. I really honestly could not stop thinking about how the magistrate treated me, and I needed to know why. And it didn't help that he only lived 4 miles from Anna's listed residency for the last 12 years, which made me even more concerned because it wasn't just about losing my case. It was about justice and accountability. And you have to understand, this really wasn't normal behavior of a magistrate. He was nice to everyone else in the courtroom, just not to me. I mean, even my best friend, who's an attorney in California, said she's never heard of a judge or a magistrate treating me that way before. They don't even treat criminals that way. So yeah, I decided to file a formal complaint against Magistrate Williams. Now you'd think that this would be a straightforward process, but it's not unless you live in Mecklenburg County, which is the Charlotte area. They actually have a formal complaint process, but guess what? In Wake County, there's no clear guidance. And that's probably by design. They make it hard, make it confusing, and most people are just going to give up. But if you do live in Wake County, or your case involved Wake County, the only option is to mail, not email. You have to actually mail a written letter to the Chief District Court Judge, which is currently Judge Margaret Eagles. Now, I documented every instance of misconduct in detail. I included copies of everything I submitted at trial, and understand that filing this complaint was not a decision I made lightly, especially since he accused me of never being happy and I just report them to their bosses. I feel like he kind of said that as a way because he knew he was doing something wrong and he was trying to discourage me from doing that. But guess what? I felt it was necessary because if magistrates are not held accountable, the system will never change. And I wasn't doing it for myself. I was doing it for every tenant who would find themselves in my shoes. I did not want anybody else to experience that. But honestly, I don't know what good it did because 2 months later, I got a letter from Judge Eagles saying that it was reviewed and closed. That's it. No explanation, no follow-up, no accountability. For comparison, by the way, Mecklenburg County's process only takes 30 days and you can actually request a resolution. I even filed a public records request because under the statute, if disciplinary action was taken, they are actually required to disclose it and provide it to me. What did I get back? Nothing, no records, which means that no action was taken or the court violated their own statute. And that's a problem because then there's no real transparency, no external oversight, and the judiciary that essentially polices itself. And when the Chief District Court Judge is the one responsible for making sure things in small claims and district court are running fairly and she doesn't, well, it lands people like me in the situation I'm in. Now, at the same time I filed that complaint, I also filed my appeal, which in North Carolina is called a trial de novo, which means that you get a completely new trial in district court. Now, after what happened with the magistrate, there was no way I was trusting another judge with my case. So I opted for a jury trial. I know that this would be more complicated, but I also felt like it was the only way I had a shot at real fairness. Not to mention, I was planning on filing for a summary judgment because I know that I had enough facts of evidence that were not being disputed. She wouldn't be able to use my character in district court, at least so I thought. Now, as soon as I filed the appeal, the court, of course, schedules me for this mandatory arbitration. This is standard in North Carolina for civil cases under 25 grand. Arbitration is kind of like this mini trial. It's not like small claims, but instead of a judge or a magistrate, you get an arbitrator, which is just another local attorney. So their decision isn't binding, though, and you get to appeal that too. But the whole point is that you try to get the case settled and it frees up the court. But of course, that wasn't going to happen in this case. Now, the arbitration hearing was scheduled for November 13th, almost 3 months after I filed my complaint. Now, these hearings are limited to 1 hour and aren't recorded. So I had to stick to just key points. I couldn't even share the full story. But at this time, I wasn't bringing just an email. The whole case had actually gone through and it shows that she violated it. And I had the entire case as evidence, which showed also too that the fireplace couldn't be certified for safe use. I mean, there's no way he even looked at this evidence because I was awarded nothing. What made it even more frustrating was the fact that no explanation is also given, right? Nothing. It just says, no, the plaintiff gets nothing. But honestly, I wasn't surprised. From what I've seen, every arbitration decision that I've reviewed in original small claims ruling is like a rubber stamp. They just match whatever the previous judgment was. Now, you can request to be exempt from arbitration, and if I had to do it over again, I absolutely would. It wasted my time and it only dragged out my case even longer. But when you appeal an arbitration decision, you get 30 days this time instead of 10. Now, quick note, deadlines are so essential. So weekends count when calculating your timeline, right? Then the clock starts the day after something's served or judgment. Now, if the deadline lands on the weekend, it's going to automatically roll to the following Monday, right? So if something's due like 30 days from something and it lands on a Saturday, it gets moved to that Monday. Now, I knew I was going to appeal, but during those 30 days, I studied my butt off because now that we're going to district court, I was required to learn the North Carolina rules of civil procedure and the rules of evidence. On top of that, you'll have to know the rules specific to district and superior court, which is another set of rules, plus another set of rules, which is a local district rules. Okay, so that's 4 different sets of rules. I also took 2 fast-track law courses in civil and constitutional law during that time. Now, luckily, we live in a time of AI, and it's an amazing tool if you can use it right. Now, understand they're not going to be able to give you legal advice, and it will state that if you try, but you can use it as a coach or a paralegal. So for my case, I used ChatGPT and Claude. I created separate projects in each because I wanted to compare the information between the two. Now I uploaded these projects, the laws and the rules, and I had them break down things to me in like plain English if there was something that wasn't clear. Then I organized what rules were applying in my case that I had to really worry about because there's plenty of ones that you don't have to worry about. But there is a catch to this. you have to, and I'm going to stress this so much, fact check everything. If they put in a case law or a statute, you need to check that because they will include fake statutes or quote cases that don't exist. If you use ChatGPT, you can ask for source citations. Like, so if they say if they reference a case law, you have to ask them where they got that from. If it doesn't provide one, you can search the citation directly via Google. Even if it looks real, though, let's say you find the case, even if it's the real case, you should download the case and re-upload it back into AI in a separate chat and ask them to summarize it and see if it matches. Because sometimes they reference a case law that has nothing to do with your case either. But you can also use AI for creative purposes and ask it to play a defense counsel acting in bad faith and see what tactics they may come up with. So it's a really amazing source, and we're very, very lucky to have it. But again, I'm going to stress again, double check all of your filings before you do so. Now, once it reaches district court, defendants are required to submit an answer within 30 days of your complaint. They do not have to do that in small claims. An answer is them either denying their claim or denying your allegations and what their defense is to it. If they're not able to answer this in 30 days, it automatically puts them in default and you could win your case. This allows you, though, also to start prepping for their defense, and then you can engage in discovery. You actually can start discovery for the first time the moment your trial gets accepted into district court. And this is something I had to do actually really quickly because the hearing was scheduled really quickly. Now, in the simplest terms, discovery is about gathering supporting evidence you know exists, whether that's documents, cross-examining witnesses, or questioning defendants before the trial. And I was told this could be a very difficult process, and it can be, especially if you're deposing somebody. But I didn't take that route. I took all the easier routes and keeping everything in writing. Now, in my case, they obstructed discovery by refusing to answer properly, and they were using these boilerplate objections. If my case was still in district court, I would have had the judge compel them to respond, and then the attorneys can face consequences for that kind of obstruction. But my case isn't in district court anymore. It's actually in the Court of Appeal, and we didn't even make it to trial. That's because North Carolina allows something else called an interlocutory appeal. Not all states do. It's basically asking the Court of Appeals to step in before the case is finalized because your substantial rights are being violated in a way that causes irreversible harm. The reason for this is because once my case got to district court, things just spiraled. Now, this court is supposed to be faster paced, but attorneys are going to file every delay tactic they can. Extensions, motions to dismiss, procedural gamemanship. They want to wear you down or trip you up or kind of bait you into doing something wrong. And that way it can get dismissed off a technicality. But it also tells you a thing, right? If they have to stoop to that low, it just means that they don't have a real defense. Because if they did, they wouldn't act this way. But I think what shocked me the most wasn't even the way the attorneys behaved, it was how the court did. Now, judges rotate weekly. So in district court, you don't get a judge assigned to the case like you would in superior court. So one judge to each case. In district court, they rotate it. That means each hearing, if you have a motions hearing, it's going to feel like starting from scratch. And it also gives opposing counsel a kind of a free pass to contradict themselves without consequence. And of course, right before the trial, Anna decides that she wants to switch attorneys. Now, this is only supposed to be allowed because once you make a notice of appearance, there has to be a justifiable cause for them to withdraw and substitute. Despite, of course, a judge trying to tell me otherwise, but I guess we'll see because this is part of my appeal. And this was just what happened. There was no consistency. There's no accountability. There's absolutely no fairness. And for someone like me who values justice at their core, this was extremely soul-crushing. They delayed my case over and over. My amended complaint that I ended up filing with my appeal added actually a defamation claim. And then opposing party became fixated on that, using it to stall everything. And of course, because of the substitution of counsel, they have filed meritless motions, didn't follow proper notice, and they still have gotten favorable rulings. I've objected. I've cited the rules. I followed the letter to the law. I have not screwed up once, but the judges have either ignored my filings outright or they just tell me it doesn't matter. One judge granted a continuance without any written cause and not even allowed because the opposing party is supposed to file a motion to set aside judgment. And so when I asked for reconsideration, he literally told me I wasn't allowed to speak if I was trying to change his mind. Okay. Another judge blamed me for the delays, saying it was my fault because the case was aged, and it was only aged because I decided to appeal my case. If the case has been in the record for over 180 days since the filing, it puts your case into this aged case status and is supposed to go faster and not allow delays. She even extended discovery past the trial date without cause and said, if I didn't like it, I could either continue the trial, which would cause another delay, or I would have to proceed without discovery, which is a fundamental right. and not allowed. That is not justice. And what's even more disturbing about this was the lead civil judge making these rulings in Wake County. So she should have known the rules even better than any other judge. And then it gets even worse because then she admitted on record that the chief district court judge, Margaret Eagles, had decided to deny my motion before the order was filed. Like, she gave me the message from her. That's improper communication and a clear sign of prejudice. Even if there's not one judge assigned to your case in district court, judges are not allowed to talk about the cases before a hearing because it violates judicial conduct. Oh, and that ruling that she said was denied, that the chief district court judge filed, contained factual errors and referencing motions that have been withdrawn and did not even consider half of the things that I addressed in the motion. But the final straw came when I filed this interlocutory appeal, because once you file, the court is supposed to pause. There is supposed to be an automatic stay, goes into effect if your substantial rights have been violated. So I emailed the trial court administrator when I filed the appeal, said, hey, by the way, that hearing that we have coming up this week, it should be canceled because of this automatic stay. And she's like, oh, you just need to update them once you get to the hearing. Like, I had nothing else to worry about. But instead, the judge ignored it and held a hearing anyway, saying that he felt like this was going to be argued. How did you know that? Because it wasn't supposed to be argued, and the opposing party didn't file any objection, which he should have, but the judge just had a feeling, and he said, we'll meet back in an hour and a half. I had to wait an hour and a half to get to this. And in this hearing, the judge ends up mocking my file, telling me I'm not an Atticus Finch. And the problem with this generation today is they think everything should just be done quickly, and how this isn't the Brinks robbery. And my case isn't even that big of a deal. Like, why am I only bothering if it's only $5,000? Comment after comment that's so inappropriate. I'm sorry. I'm like, you have no right to tell me what my case is important. If it's important to me, that's all that matters. And then, of course, he sat there and complained about other self-represented parties and how they screwed up because the opposing party was trying to imply that all these filings were my fault. And then the judge and I started arguing over a specific law. And it got to a point where I'm like, I'm not doing this anymore. Like, let's just agree to disagree because I'm right, you're wrong. I don't care if it was a judge. He was wrong. This law is so straightforward and there's no room for interpretation on this. But either way, this hearing goes on for 40 minutes. I can't even tell you what happened half the time because I'm just sitting there like, kept saying, like, what is going on here? Why are we having a hearing when this is supposed to be stayed? And he'd be like, well, this isn't a hearing. We're just talking. Then why am I here? And then all of a sudden, out of the blue, he just stops and says, okay, well, we're going to come back tomorrow at 3 p.m. and we'll discuss this further. I'm like, wait, what? No, like, you can't do that. You can't just tell me to come back at 3 p.m. the next day without notice. And I was tired. I was tired at this point. I'm like, I am so sick of having to go to these hearings and being badgered and attacked for no reason. So I filed an objection that I was not going to attend the hearing. And then I filed a motion for supersedious with the appeals of court and this temporary motion to stay. And the judge was not happy about it. He sends me this email, so inappropriate, that states that I don't know how things work, which I don't know what he was referring to when he said things, suggested that I get an attorney, which he's not allowed to say, and then accused me of a scorched earth approach for simply asserting my rights. That if I had a problem with the hearing, then I should have just asked if we could do it a different day. Yeah, because I want this delayed even more. Yeah, can we just do it next week? No, that's not how this works. Then his written order misrepresented the record altogether. He claimed this was an eviction case when it wasn't. And he selectively ruled on motions in favor of the opposing party and didn't even acknowledge mine. I mean, at this point, this isn't just bias. It was like either a systemic failure or a result of undue influence. This is not subtle. Also, out of those 4 oral hearings that I had to attend, including the small claims hearing, so 3 out of those 4 hearings, 3 times, I was placed dead last. And it wasn't because this time around mine was the longest, but I still had to wait there and listen for everyone else to go through. These judges, the lead court civil judge and this last one, was so condescending, and the defense and using it and quoting it as improper comments in their own filing, like this was a legitimate support, which is a little disturbing because it indicates like this ex parte communication. Like, he's making it seem like he's kind of like in cahoots with these judges. On top of that, ex parte orders were granted weeks after they were filed, and only after I submitted something in my favor. When she replaced this attorney, I was actually kind of happy because I was like, oh, maybe I'll get a decent attorney this time. She just picked a bigger law firm called Hatch, Little and Bunn. The irony in this is I actually reached out to them and they refused to take my case. I think she went about it in a way where she got this lawyer to intimidate me because they're at this big law firm. But I think she picked like the lowest one because honestly, like, he's not better. He's just dirtier. I mean, he lies outright in these filings and then claims he wants to work things out Well, then he goes back to the court saying that they should file a gatekeeper order against me that prohibits me from filing anything. He even filed a countersuit that violates procedure and is packed with these false statements. And then he has refiled that motion to dismiss. That's the third time this motion has been filed and it's been denied. He's not allowed to do that. And what's even more disturbing about this is that the Chief District Court Judge, Margaret Eagles, is fully aware of my case. And even she has made moves that appear improper. So right now, I could file a formal complaint against her, that lead civil judge, and the other judge. But the truth is, I don't know why they're acting this way. It's either because they don't fear consequences, or they think a pro se like me doesn't carry any weight, or that I have no idea what I'm talking about. It's fine. If that's the case, then I'm wrong, I'm wrong. But if I was wrong on this, then why have I not been violated? Why has my case not been dismissed? Instead, it has to be all these undercutting and underhanded actions. Because throughout this entire process, I have documented every violation, every irregularity, and every instance of bias. I have filed objections. I have filed motions to reconsider, notices of appeal. I have kept a detailed judicial log, something that I now plan to use in my appeals. Let me be very clear, I did not want to file an interlocutory appeal. It is a long process that takes months. But by the time I did, I had no choice. I believe this was meant to happen. I'm in this unique position now. And there are studies that show how rarely pro se litigants make it to the Court of Appeals, because most cases get tossed out on technicalities or the pressure just becomes too much. Now, the Court of Appeals is a big deal because it's where law starts to matter. It's where change can be made. But for some reason, I don't know if it's the opposing party or if it's the trial court or what, but they are doing everything they can do to try to block my appeal. About a month and a half ago, after what happened in that last hearing, I said I had to file something called a Writ of Prohibition, which is basically asking the Court of Appeals to tell the trial court to stop doing what they're doing under the statute. Now, these are really, really hard to get approved. Most are denied, no matter what, because the Court of Appeals doesn't want to step on the little court's toes, basically. And they don't like to interfere. So they try to hold back to see if the trial court will correct itself, but they can't just let it sit there. They have to eventually rule on it. I have such a strong argument. It almost is nearly impossible for them to deny it. Now, on top of that, I have to file this appeal, and the appeal process is not easy, right? I had to put together an over 200-page record on appeal, which is where you put all the evidence together that shows, your evidence to what you're going to be filing your case on. And I've obeyed all the rules so far when it comes to this appeal. I've been above the timelines. And once this record on appeal is docketed, that makes your appeal solid. This is the most important part of the appeal process. And so I knew that me sending this to the opposing party, so once you get it done, you have to send it to the other attorney, and they get 30 days to review it and file objections against it, and they can ask to change things in it. And I knew he was going to try to do this. I served him this proposed record on March 5th. But when April 4th came, I never heard anything from him. So I was like, okay, either he's not doing it because he's trying not to acknowledge the appeal, or he screwed up. I knew most likely that he screwed up. Now, once midnight, that record is settled. According to the rules, 11B of the North Carolina Rules of Appeal, it's settled. There's nothing that can change that because he didn't file it on time. So once you send the settled record to him, which I did Monday at noon, instead he does end up sending me objections that evening, around 8 p.m., tries saying, okay, look, let's say how you want to work this out. And I'm like, there's nothing to work out. You're late, buddy. It was due on Friday. Now he makes up this elaborate thing saying oh, I didn't serve him properly, which I know I did. So I'm like, go ahead, file the motion. So he files this motion for this record on appeal under this writ, which I'm like, you can't do that, buddy. This has nothing to do with the appeals. There's no rule anywhere that states that he can do this. So let the Court of Appeals know he can't file that. I'm going to ask him to strike the motion, throw it out, not even worried about it. The Court of Appeals rules on his motion and grants it and denies my motion to strike. I can't put this into words. You're supposed to be a little bit safer at the Court of Appeals, but now all of a sudden this is happening. Nowhere. I am telling you right now, and any attorney that's listening to this wants to deny me on this, please, there is no way under Rule 22C of the North Carolina Court of Appeal, they cannot rule on a motion that has nothing to do with the writ. This is an in limbo thing. And not to mention, they have to give me a certain amount of time and without giving me the opportunity to be heard, because I filed a motion to strike. And even if they say, well, that was your response, well, that motion to strike had nothing to do with his request for an extension because it wasn't valid. So what they should have done is said, we're going to deny your motion to strike, but we're going to give you the opportunity to return to this, if this is even allowed. So I've filed an emergency motion to reconsider. I mean, they literally have blocked my entire their appeal. There is nothing I can do. This is exactly what happened in district court and why I was forced to file this appeal, because they put me in this position that stuck. I couldn't move forward. If someone wants to tell me this is an undue influence and this is just systemic bias, okay, but that's pretty scary. If they deny my motion to reconsider, which I had to file an emergency motion to reconsider, if they deny that, my next step is that I either have to file this motion for en bloc, or I don't even know how you pronounce it, which basically is a motion asking the entire Court of Appeals to rule on this motion instead of just 3 judges, which I don't even know who those 3 judges are because I don't get privy to that information. Or I have to file with a motion with the Supreme Court asking for them to step in. It's so not normal and so disturbing. This case should have been over months ago. But if you're telling me that all of this is normal, then North Carolina's court system has completely failed. So yeah, I'm not just fighting Anna anymore. And you know what? This is only half of the battle because there's a whole other part to this. Are you guys ready? I'm not done. Okay, remember how I said I had multiple claims? Now the state court case, all the stuff that's happened in the state court, is only focused on the warranty of habitability, misrepresentation, and defamation. But Anna's actions, whether directly or through her attorney, everything that's happening in state court, every filing that they filed as an intimidation tactic or improper can look to as retaliatory. It's called an abuse of process. And that's when someone uses the legal system in a way that technically is legal, but for the purposes that it wasn't intended for, which is to harass, intimidate, or delay rather than seek actual justice. And the irony is that this is the countersuit that they actually filed against me, which is a complete joke. Honestly, though, I believe that nothing would have happened this way if the North Carolina Human Relations Commission had actually done their job. Instead, they decided to pour gas on the fire. When you file a complaint with the North Carolina Human Relations Commission, they have 30 days from the time of the complaint being filed to assign an investigator. And of course, they waited till the very last day. Now, I started emailing her because I had all these questions and nothing. And I called, left the voicemail, nothing. So on October 22nd, I was getting frustrated. I emailed the program manager who said he would have her contact me, but she didn't. Fed up, by November 2nd, I decided to email the director of North Carolina Human Relations Commission, who's an attorney, Jonathan Ekblad, asking, I want a new investigator. He responds 2 days later, insisting that all these complaints are so taken seriously, and he refused to reassign it. Finally, she asks me for evidence, and I tell her too during this time. I sent her everything, and the fact too that my address had changed. Again, this is black and white to me. Like, Anna did not follow the statute rules. I have enough evidence to prove that. There's no way that she can dispute this. Now, she explained the very next step was to contact Anna for evidence and then attempt something called conciliation, where she says, hey, this is what they're looking for relief. Do you want to conciliate? Do you want to negotiate? But right after this, because that was on November 12th, right? So the very next day, we have an arbitration hearing. Anna's attorney brought up this complaint and said that they had found no violations. And I'm like, really? Okay. So either they are violating the rule of ethics by lying, or they had access to information that I didn't. According to the statute in North Carolina, they have 90 days to conduct this investigation, which was on November 25th. And if they go past the 90 days, they have to give you a written reason why. Never got that. Then the 100-day HUD deadline passed on December 6th. Again, no notice, violating federal law. Finally, I'd heard from her saying she was going to reach out to Anna now. Now it's been a month and you haven't even spoken to her. On the 20th, I was told that Anna had declined conciliation and she was not willing to negotiate anything, and that I had nothing to worry about because right after Christmas, there would be a determination, but there wasn't. So I waited. I even gave him a little time. In January, I followed up again. And then I said, you have to tell me what's going on here. Why is this being delayed? You guys haven't given me any formal notice. You have until January 14th to do so. And she first started saying the holidays. And I'm like, well, past deadline a month and a half ago. The holidays have nothing to do with it. Of course, she did not give me any kind of written or formal explanation. So I contacted the director again, who gave a very conflicting story that the final decision had been made, but it was sent back to her because it needed to be narrowed down. Then I get another email from the investigator saying that new evidence had just been submitted, but these delays and contradictions violated both state and federal regulations. I emailed HUD, like multiple regional directors. I didn't know who to email, so I just emailed a bunch of people and the director of the Office of Inspector Generals, which is supposed to oversee all this. But yet nothing. Little did I know that when this was going on, the NCHRC to make a finding, and they sent it to me, except I didn't get it because they did such a poor job in this investigation. They didn't even update my mailing address. So finally on February 10th, over 5 months after filing, they oh, there's no reasonable grounds, but you have the right to sue her now in federal court. Well, of course they didn't, because you know why? Because they didn't include any of the evidence I gave to them. They didn't address the retaliation at all. They just totally ignored it. The findings are filled with mistakes of wrong dates, completely misrepresenting my actual complaint, direct lies by Anna that if they would have looked at their evidence, they could show that it was actually contradicted. This was just full of procedural violations, and it failed at every standard for a fair housing investigation. So next day, appealed to the HUD's Fair Housing Enforcement Office, the national one. But HUD did eventually respond on March 5th, claiming that they had no jurisdiction and they couldn't help me because NCHRC had already reviewed the case. Okay, this is what drives me nuts. Like, don't talk to me like I'm an idiot. Do you think I don't know how to read a rule? If a state agency that is controlled by HUD fails to properly investigate, HUD is supposed to take over, especially when that complaint was dual filed like mine was. Now, I could have filed the complaint with HUD's OIG, but let's be honest, like that just would have dragged us out even more. It takes weeks to hear back from them. And at this point, I don't even know who's been fired or what department's still functioning according to the federal administration right now. So I will handle this myself. No one's helping me, fine. Now, I knew that she tried to use this flawed investigation to her advantage, which she absolutely did because she included it in her countersuit. So I decided to file a petition for a contested case hearing against North Carolina Human Relations Commission for failing to properly investigate and for violating my rights, which is done through the Office of Administration Hearings. I could have taken this to the Superior Court for judicial review, but it would just take too long, and it also costs $200. Like, why should I have to pay $200 for their mistakes? Now, the only problem with this is that the North Carolina Human Relations Commission is a division within the Office of Administrative Hearings. So again, this is an agency having to look at their own commission for wrongdoing. But I was like, you know, I'm going to give them a bit of the doubt because I'm allowed to do this. They write the law on how administration agencies are supposed to act, so they should be able to enforce it. The case was accepted and assigned on March 12th. Now, 2 days later, an attorney with the DOJ appears as a defense lawyer for the North Carolina Human Relations Commission and proceeds to file this complex, legally filled 15-page motion to dismiss, claiming I was appealing the investigation, which I wasn't. I find this so disturbing. The DOJ is meant to defend state agencies in lawsuits, but I wasn't suing them for damages. This is a standards review process, and it's confusing to me of why they would even get involved when the North Carolina Human Relations Commission has their own counsel. Not to mention, it circles back to the very beginning, as they were the first agency to fail that led me to file with the North Carolina Human Relations Commission based off of their suggestion. Now, the DOJ is meant to protect the civil rights of citizens of the state and prosecute those businesses and agencies that violate them, but instead, they're now defending an agency that violated them in an aggressive and an improper manner. Why are they doing this? So I file a motion to disqualify the DOJ due to a conflict of interest, and the judge actually ordered the DOJ to file a response to my motion to disqualify with a memorandum of law. Then on April 1st, the DOJ responded to the judge's orders, but didn't provide that memorandum. Instead, a prejudicial affidavit from a manager of the DOJ about my complaint. They include one message, not all the other ones, saying that nobody gave me legal advice. No one told me to do that. This affidavit, though, is actually hearsay and it violates the rules of evidence. So, of course, I immediately file a motion to strike their response and the affidavit stating like they didn't do what the judge asked them to do. So they shouldn't be able to file this motion. And that's when all hope was lost, because the next day, the judge denied my motion to disqualify and motion to strike. She claimed it was because they weren't a personal attorney of mine, that it's not a conflict of interest, even though the law of ethics state that that's not a requirement. If there's a third party conflict, they have to actually adhere to that. The judge then also orders a hearing on the motion to dismiss after stating a hearing would not be conducted unless requested, which it wasn't. You don't just change your mind in an order or go against your own ruling unless there's a specific reason for it. Now, I filed another motion to reconsider an objection to the further hearing. Now, she ruled on this today after me forcing her hand because it's been a week, even though she ruled in every other motion, which she did refuse to disqualify him, but she canceled the hearing. And then she goes to say, I have 45 days, 45 days to review this motion to dismiss. That's fine. I don't even care. You could take 45 days because guess what? I'm filing a motion for summary judgment. I have very straight facts on this. Again, this is black and white. There are certain rules that they have to follow. There are standards that says you have to do A, B, C, and D, and they didn't do A, B, C, and D. There's no way that there's a summary judgment can't be found. I just want the judge to say, hey, you guys fucked up. The investigation is valid. It can't be used in any court hearing. But what's really concerning about this is that this is really rare to find a petition case. I did have to do extensive case law research. There are only 3 other cases in the past 20 years filed against the NCHRC. One was dismissed for no explanation. Another was dismissed because the person was trying to get people fired and sued directly, which they can't do in a contested case hearing, which ironically, the same DOJ attorney on that one is the same one that's on this one. So he even knows that my complaint is not like that, which makes this very interesting. Now, I found 5 cases total that reference the North Carolina Human Relations Commission. And in all of these 5 cases, every single one of them mentioned the same thing. Evidence was omitted. There was a failure to properly investigate, yet no one is holding them accountable. I am the first person in 20 years to push this through in the right way because they don't tell you. Most people think that their only option is that they're going to either try to appeal it through HUD or they have to go to federal court and sue that way. And that's a huge process. Like, costs a lot of money. It costs $400 to file a case in federal court. But you have to understand, this isn't about money or trying to get back at her. This is about the fact that she violated my rights. But I have spoken with other North Carolina residents who have gone through tenant issues, and they all say the same thing. Like, there's no real recourse here. There's nothing they can do about it. When a state operates without checks and balances, the system is going to break down. This is supposed to be the foundation of our entire government. And right now, North Carolina is failing at that. If you want more proof, North Carolina is an outlier in restricting access to cases. But when it comes to district and superior court, you can find the information online. It just takes hours because you have to go through each of them manually. Or you know what, you can pay $400 for a one-time access, or about $3,000 to get a data set. I mean, that's insane to me. Come on. But it also made me believe that there's a reason why they do that. So you know what I just did? I conducted the research myself, basically copied all of the information, and I put it into an Excel sheet, which then I narrowed it down to summary judgment eviction cases in Wake County, by the way, not the entire state, and then money owed cases. I went manually through each of them to find out what was a tenant for suing a landlord. This is to show if there is some kind of prejudicial bias. I found out that in 2024, there was 113 cases filed against landlords, okay? Yet there was over 10,500 eviction cases in Wake County alone. What's interesting about this is that there is also 124 unfit housing cases reported in Raleigh during 2024. Out of the 113 cases, a lot of them had to do with like security deposit issues because that's a whole nother law. What's interesting is in 2024, I found 3 other small claim cases where the city had cited for a code violation against the landlord. All 3 of those cases, the tenant won at least some amount of money. Not fully, but at least some. Somehow my evidence wasn't strong enough, which one of them was the same magistrate that ruled on my case. This was an increase from 2023 because in 2023, there were 71 cases filed against landlords and over 9,000 eviction cases. Now, what's interesting about this is that these money owed cases, it's about 23% are denied, about 23% are like fully granted or partially granted. And then the rest are like involuntary dismissals because people don't show up, or the status is not updated properly on the record, which a lot of them aren't. I randomly chose like 267 eviction cases in 2023 to see what is the outcome from winning to lose. Only 2 were denied and a lot were appealed. And out of those appeal, 3 were actually overturned, showing that looks like small claims court has just become like kind of a factory where you're just going to lose. That's not a fair system. That's bias. That's a pattern, and it needs to be called out. So in the end, why does this matter? Because I get it. Some people hear government corruption and then they just shrug because they're used to it. They assume it's always been that way. Nothing's ever going to change. But that's exactly the problem, because when people stop caring, when no one pushes back, things just get worse. No independent watchdog holding government agencies in check. There's no oversight. And so misconduct festers because the system protects itself, not the people that it's actually meant to protect. Not to mention, there's also been concerns about weak campaign finance laws and lax enforcement, which in the state, which can foster an environment where corruption definitely thrives. Reports have indicated that politicians have exploited these weaknesses for personal gain, highlighting the need for a robust oversight and reform. And guess what? All those judges that I've been dealing with, every single one of them are elected. Any state judge is elected. But guess what? It doesn't affect people just like me. I'm not the only one. It affects everyone in the state. When a state government or a court and a system goes unchecked, it starts to rot from the inside. And eventually it hurts the economy, community, and even the state's reputations. Companies will start to pull out. Like Apple was actually supposed to be building a $1 billion campus, the Research Triangle Park, that would have brought 3,000 jobs, 3,000 people, okay? But for some reason, Apple has delayed that for about 4 years. Can you imagine if those 3,000 Apple employees are moving to North Carolina and decide to rent? They're walking into a mess. They're dealing with mold, eviction, discrimination, retaliation, and realizing the court systems aren't going to protect you. Smart, ethical businesses do not want to move to a state where courts don't work and people don't have any rights and corruption goes unchecked, because it's not about the money or just dealing with that. It's going to be about the liveliness of their employees. If employees have these problems, they're not going to do their job they're supposed to be doing. But similar challenges have arisen in other states. Like, for instance, Mississippi officials misappropriated over $80 million in programs intended for impoverished children, demonstrating like corruption could definitely divert essential resources from those in need. In 2004, former Connecticut Governor John G. Rowland resigned actually amid federal corporation investigation, leading to a pleading of guilty to accept gifts in exchange for political favors. In response, Connecticut actually enacted stringent campaign finance reforms to prevent such abuses. But with more corruption, legal battles accumulate, and agencies end up expending their resources defending misconduct, and mismanagement drains public funds. Consequently, states like Mississippi and Alabama have experienced poor rankings in health and education and infrastructure due to these resource misallocations. These examples just kind of illustrate a broader implications of unchecked government actions and the necessary for vigilant oversight to maintain public trust and ensure the governmental institutions serve the public interest effectively. And if you want real change, whether it's in housing, in the courts, or a government agency, it starts with people calling it out loudly, relentlessly, like unapologetically. If that makes me a problem, so be it. I'll be that. I just hope I don't die. And if you guys, I swear to God, if I do, it was not an accident. I have very strong lifelines, okay? Very strong. If anything happens to me, make sure you investigate. But I would rather honestly be the problem and experience this than to be silent while other people suffer. The bottom line, it is up to you to decide how much you're willing to take. And I'm not definitely telling you to take the same path I did. Honestly, I hope you never have to. But if my story can save one person from the same pitfalls, if it can shine a light on like how broken the system is, then it was also worth it. Because this isn't about just a bad landlord or whether or not there was a moldy apartment. It's about due process. It's about fundamental fairness. It's about the right to be heard and to be treated equally under the law. It is when that very system that's supposed to protect those rights become the one violating it. We're not just letting people down, we're letting history down. We're disrespecting every life that sacrificed to build the Constitution in the first place. Listen, I do get though, like this is a time of full of misinformation and instability and complacency. It feels like the easier option. But we are still lucky enough to live in a country where I believe freedom of speech still gives us the power to speak up. Because as Ida B. Wells Barnett said, the way to right wrongs is to turn the light of truth upon them.